Hello, this is David Spicer. I'm the instructor for jail standards. Today we are going to be talking about constitutional rights. These are rights that we as American citizens and humans are given through the U.S. Constitution. The U.S. Constitution is the supreme law of the land. The states, cities, counties cannot write laws that violate what the law has been established to the U.S. Constitution and how it's been interpreted through the courts, primarily the Supreme Court being the ultimate decision maker on laws and if they're constitutional. And over time, these are always changing as things come up, and we will discuss some of those points throughout this presentation. I will also be posting the PowerPoint that you will see here in the content section of Blackboard for this course under the content section under PowerPoint presentations. The First Amendment to the U.S. Constitution grants us two basic rights. The first is freedom of religion, and the second is freedom of speech. Under freedom of religion, as it relates to jail standards and jails, once someone is incarcerated, they do not lose that right of freedom of religion. It is expected that they would be allowed to practice their faith, whatever that is, and not be restricted in that to any extent that's not unreasonable. Again, I've said before, things that you do in a jail setting or in law enforcement, you must always act reasonable. For example, if a pastor of a church wants to come and visit with an inmate at 3 o'clock in the morning, that may be normally completely unreasonable at that time of day for the safety and security of the jail and other things. But if it was for the means of coming to notify that inmate that there had been a death in the family and to console them and to consult them at that point in time, it might be reasonable. But again, you must act reasonable. And because of freedom of religion as to jail standards, allow them to practice it, but also not force them to be exposed to religion. For example, if the jail has a ministry that comes in to minister to inmates, they cannot be forced to attend those meetings. If they choose to be absent from them, they must be allowed to do that also. And also many jails have to meet the dietary needs. As I've mentioned before, at the Logan County Jail, we always would provide turkey meats instead of beef or pork, so it would meet the dietary needs as well as no problems with the religious practices of anyone whose religion may abstain from those foods. Freedom of speech, not only before they go to jail, but in jail we all have a right to freedom of speech. Now, not all speech is protected. For example, you cannot threaten to kill someone. The courts have held that is not reasonable. They've also things like communicating a false alarm. You've often heard of you can't just walk into a theater and yell fire and cause a panic. People get hurt. Things could happen. Just because you have freedom of speech doesn't mean always legal to say that. The laws do bar certain speech. So they still have freedom of speech. For example, a jailer should be able to tell you, I don't like the way you're doing this. I do not think this system's fair. They could even call you a name, and at times that may not be illegal. For example, several years ago in Arkansas, there's actually a statute for disorderly conduct that states if you make an obscene gesture that would likely invoke a violent response, that's illegal. So a officer in northwest Arkansas arrested a person who had basically given them the middle finger or the bird. The officer arrested them and charged them with disorderly conduct. That particular person took this to a higher court, and the Arkansas Supreme Court said that officers should be a little above other people and be able to withstand that, basically saying that was freedom of speech. So since that point, I haven't heard of an outbreak of this, but it's commonly been known if someone gives an officer a bird and that's kind of it, that's really not a criminal offense. And so again, even when they go into jail, they do not lose their freedom of speech. They have a right to say things that wouldn't otherwise be illegal, as long as it's not illegal in some other way. Again, on the First Amendment, they have freedom of religion, they have the right to practice it, but also cannot be forced to be exposed to other religious activity that may be going on in your jail. Again, freedom of speech, they have a right to express their opinions about things, but again, threats that would incite others would not be considered protected speech. Not all speech is protected, and the courts have ruled that. And also, you should also be careful about taking any action based on words alone. Now, if someone just says something, that's one thing, but if their body, they're physically doing some other kind of movements, that might be the time for action. The Fourth Amendment. This amendment protects the individual from unreasonable arrest and unreasonable searches and seizures. Again, I've said in class many times that I will use the word reasonable or unreasonable several times, and this is one of them. The Fourth Amendment does not say that a person cannot be searched. It merely says that searches will be reasonable, that they will not be unreasonable, and protects individuals from unreasonable searches. So searches are necessary in jails. You're going to search people as they come in. Of course, they don't have to have a search warrant for that. Courts have held that that's reasonable to search someone as they come into the jail. Also, when they're in the jail, for the safety and security of the jails, searches of the jail cells has also been held to be reasonable. However, strip searches have sometimes been found to be unreasonable under certain circumstances. People coming into a jail for a misdemeanor, the courts have held that it's unreasonable to search them unless there's some exigent circumstances. For example, they have had a history of attempting to sneak contraband into the jail before. That might be reasonable under that. Because of that, the Arkansas detention standards for detention facilities requires a written policy on strip searches. Again, on intake or reception of prisoners in the jail, there must be a legal reason to place the person in jail to begin with. Because when you take someone and put them in jail, you have seized them. That is a seizure. You've taken the person. You think of a lot of times a search and seizure, you may think of contraband or illegal property that's been taken from somebody that's in violation of law. When you take the person themselves, that is also a seizure. You are seizing their body and you're placing them in jail against their will. And so there must be a legal reason to place a person in jail. Again, documents must exist. There must be some form of document, a warrant, a ticket, a form that the officer placing the person under arrest has filled out saying what the reasonable cause or probable cause is for that arrest has been. Also, the search of a person, an area, even in detention, a person has a right to reasonable amount of privacy. For example, again, strip searches for misdemeanors have been found to not be reasonable except under certain circumstances. Also, a person should be allowed to go to the restroom, do bodily functions without being viewed by video. And also, a search should never, ever be as punishment or a destructive action. When doing cell searches, when we get into the cell search section, we will talk about going in and throwing everything in the middle of the floor and tearing up the property of the inmate. That should never be happening during a cell search. Okay, the Fifth Amendment to the Constitution protects the individual on two levels: the right to not incriminate oneself and ensures the right of due process. Now, you have probably heard of the Miranda rights, or heard them said at some point in time, especially on a television show or movie. You have the right to remain silent. Anything you say can and will be used against you in court. That came about from a case of Miranda versus Arizona, that the higher court said that not only do you have a right not to incriminate yourself, but when law enforcement has you in custody and they are going to ask you questions, you have a right not to tell on yourself. That right continues with the person even in jail. Also, that due process. The Fifth Amendment ensures that there is going to be due process when our life, liberty, or property is taken from us. And due process is the ability to have an effect on how that turns out. For example, hearings should be held for disciplinary actions when someone's liberty or property is going to be taken from them by the jail. And due process is going to depend on how complicated the charge is. For example, due process in a jail setting for violating a rule may be simply a hearing where someone not involved in the incident hears both sides of the story and makes a decision. where it can be really complicated, whereas in a criminal court proceedings for the death penalty, it's going to be a long, ongoing process with many people involved, lots of court hearings, lots of attorneys, lots of evidence, lots of appeals involving a lot of courts. So due process is always more complicated for the seriousness of what we're looking at. Okay, the Sixth Amendment allows someone the right to counsel. Jail standards allows for a person who's incarcerated the right to have counsel with their attorney. Again, reasonable. Also through phone calls, letters. For example, mail that comes to the jail from an attorney's office cannot be opened for inspection or searched except for in the presence of the inmate that the mail is to. Mail that they write to an attorney is not to be looked at. They conceal that to the attorney, and of course jails have to ensure that the names and addresses on these envelopes are in fact going to an attorney's, that they're not trying to circumvent that some way. Again, the right to counsel unmonitored in rooms that are not recorded, telephone calls are not recorded. And again, here's that word again, this visitation, these calls should be during reasonable times. But you cannot keep this from the inmate. The Eighth Amendment protects the individual from cruel and unusual punishment. And this extends to not just when you think of cruel and unusual punishment, their punishment they receive, but in they being housed in the jail. And the things you do there daily, medical, dental, food, things like that. Courts have held that, for example, if an inmate has a toothache, an abscessed tooth, and it's hurting them badly, that the jail failing to take action to get them to the dentist to take care of that could fall under cruel and unusual punishment. You could be sued for that. Other things, though, could also be cruel and unusual punishment. All discipline must be fair and equally applied. You have to treat all inmates the same. You can't punish one for one thing and punish another for the same thing and do it differently. You have to treat them fairly. And again, also cruel and unusual punishment can be cited in use of force situations. Some people would argue that using a physical force at times, if you use excessive force, that was cruel and unusual under the circumstances. Again, all of your actions should always be reasonable, and you do not have to worry about this. If you're always reasonable in your actions, you should be okay. The 14th Amendment, again, what actually happened was the courts held that well, not the court held, but there was a problem in the Constitution that some states felt that the due process part of the Constitution didn't apply to the states, that was only on a federal level. The 14th Amendment came out and said, no, this due process also is applied to the states, and it also added that everyone has the right to equal protection under the law. The law is to be applied to everyone in the same manner. Justice is supposed to be blind. It doesn't always work out that way, but it's the best system in the world, and we need to continue to do that. And when you handle and deal with inmates in the jail, you need to make sure that you do not interfere with their right to due process in certain circumstances, and that you treat them all the same. Do not treat one better than the other. Apply the rules to everyone equally, and that will help keep from problems arising. All right, that ends this lecture. I look forward to seeing you guys in class. There will be a quiz at some point posted over this. If you have any questions, feel free to contact me. Thank you.